Republicans in Louisiana are trying to use the Reconstruction amendments that were for black people now against black people for white people. Ruling from the Fifth Circuit, which has a reputation as one of the more conservative appeals courts, is a victory in the near term for the ACLU and other plaintiffs who sued to block the state's map from taking force. Still, any relief for plaintiffs from the appeals court ruling is likely to be short-lived. The Supreme Court in March heard oral arguments in Louisiana versus Callis, which also centers on the legality of Louisiana's redistricting map and whether race should be considered a factor in drawing new congressional districts. Oral arguments then focused heavily on whether Louisiana's redistricting efforts were narrowly tailored enough to meet constitutional requirements and whether race was used in a way that violated the law, as the appellees allege. The Supreme Court in June said it would hear additional arguments in the case in the fall term, citing the need for more information before it could issue a ruling. Earlier this month, justices ordered both parties to file supplemental briefs by mid-September outlining in further detail arguments for and against Louisiana's proposed map and whether the intentional creation of a, I love this on my Congo, and Scott, I can't wait to get your legal, whether the intentional creation of a second majority black congressional district, quote, violates the 14th or 15th amendments to the U.S. Constitution, unquote. So, Ome Congo, the white Republicans in Louisiana are trying to use the Reconstruction amendments that were for black people now against black people for white people.
Wow.
Yeah.
And they've been doing this for forever, right? They are twisting everything that we fought for, whether we're talking about the Civil Rights Acts, like they're using the basis of everything we fought for. Again, they're throwing it in our faces. And this is one of the reasons why Trump has been targeting all of these law firms, so people are going to be around to stand up and have our backs. I mean, there are many that have been fighting, but some of these big ones that have caved in, they're like, this is so outrageous, but it's in their playbook. They will take everything possible. And the fact of the matter is, when you think about how people are abandoning Texas black Democrats, and you talk about, this situation now in Louisiana and other parts across the country, they do not care. They will take language that we created, critical race theory, or slang terms like woke, throw it all back in our face. They will take constitutional amendments that we fought for that help give so many other people access to the American dream throughout time, where we can talk about, they will throw it all back in our faces and say, now we're going to use it to protect themselves. This is absolutely ridiculous, and it should enrage anybody who has not been active already or who's been sitting there behind at home and not getting in the game right now, because this is absolutely atrocious.
So what their game now, Scott, is, we're going to use the Civil Rights Act against black people because, this is hurting us white people. So in Louisiana, they have literally discriminated against black people. Matter of fact, hold on. I was just showing y'all. Now, that was a court ruling. Hold on. Scott, you're going to get a kick out of this one. Federal court rules against Louisiana. Y'all going to laugh at this one. Hold on, here it comes. Okay, allowed, that's federal. This was, okay, so, Scott, you're gonna love this one. The same Fifth Circuit last week, go to my iPad. The same Fifth Circuit, Scott, last week said that Louisiana's state maps discriminates against black people. So here you got white Republicans in Louisiana discriminating against black people, diluting black power with state maps, congressional maps, and now the same white folks, The 14th and the 15th Amendment is hurting us white people because these maps should not be used when it comes to race, but, we the ones who drew the maps, and if we had actually drawn fair maps, black people would have been able to have a district. So now, Supreme Court, we think y'all should get rid of all districts where you factor in race, and that could wipe out literally half of the entire Congressional Black Caucus.
Yeah, the other strategy that we're not talking about is there are multiple cases pending in that Fifth Circuit. I've appeared before the Fifth Circuit judges. Judge Pryor, Chief Judge Pryor, at least he used to be the chief judge, is a arch conservative. And there's several cases. You see, you pulled 2 or 3, but the strategy is to file several cases with different parties in order to get several rulings. And even if they're inconsistent, then they'll wind up at the Supreme Court. The other thing is this. The Fifth Circuit, as conservative as this, these white folks in Louisiana, they're drawing maps, and in Texas and Mississippi and Georgia, they're drawing maps so blatantly racist and gerrymandered that even the conservative court, even the conservative court said, y'all can't eat all that now. Come on. You still got to have a legal pathway or a factual pathway to make this work for y'all. This ain't even fair to me.
They so racist. They are so racist. Even the judge is like,
it's for their own races.
Right, that's what I'm saying. And because here's the fundamental problem here. And this is the problem, Zabor, that the Republicans can't get around. They are hell-bent on stopping Democrats so they can hold power. And their problem is they hating on black people because they like, well, damn, y'all keep voting Democrat. And it's because you some bitches, y'all ain't making no effort to even talk to black people. So it's like they mad that black people voting Democrat, and it's like, well, y'all ain't doing nothing. So your deal is, so we gonna penalize Democrats by penalize black people, because black people, y'all problem is y'all vote too much for them damn Democrats. If only y'all didn't vote for them. And my man Gary Chambers is watching the show, and this is what he sent me. Appellants argue Dr. Alford credibly determined that voting in Louisiana is mainly polarized based on politics, not race. They offer no rebuttal, however. I don't know who Dr. Alford or Dr. King is. So Gary, you can tell me who these people are. And again, Gary has sent me like 3 different documents. And this shit is hilarious. Y'all, this stuff is hilarious reading this sort of stuff here. This is what it says. Appellants wait. They offer no rebuttal, however, to Dr. King's data, which showed that white Democrats in Louisiana prefer. Guys, go to my iPad. Come on, please. Thank you. Jesus, why? I shouldn't have to tell y'all I'm reading it. Doc, just go to it. Come on. In Louisiana, white Democrats in Louisiana preferred white candidates over black candidates, and that the same was true for black Democrats who preferred black candidates over white candidates. Notably, even when Dr. King controlled for party affiliation, i.e., analyzed data for the 2022 Democratic Senate primary, where all voters were Democrats, white voters voted for the white candidate 60% of the time, while only 26% of black voters voted for that same white candidate. Contrastingly, in that same primary, nearly 74% of black voters voted for the black candidate, while only 40% of white voters voted for the black candidate. Dr. King explained that these ratios showing more than a 2-to-1 difference were evidence of racially polarized voting. Similarly, Dr. Hanley analyzed this same data and stated that in every area, in all instances, white voters gave more support to the white Democrats than the black Democrats. Conversely, at least in the larger set, black voters gave more support to black Democrats than white Democrats. The data and expert testimony refute Dr. Alford's assertion that there is no evidence of racially polarized voting because it is politically based. Even controlling for political party affiliation, there was strong evidence of racially polarized voting in Louisiana, which Gingles found to be particularly weighty in the overall totality of the circumstances inquiry. Given that we afford great deference to credibility findings and that the district court's decision to credit Dr. Hanley's and Dr. King's analysis over Dr. Alford's is well supported, we conclude that the district court did not clearly err in finding that the factor weighs in favor of plaintiffs. What's crazy reading this is what they're saying, Zabor, and I'm coming back to Scott and finally coming from Ome Congo. What we got right here, what they saying, Zabor, is even the white folks in Louisiana are racist. And the black folk in Louisiana don't trust them white folk, so the black folks gonna vote for black people. So for anybody in Louisiana to say, no, we ain't got no race issue in the state, you done lost your damn mind.
But that's why they want to attack research and studies and all of the funding that goes to make sure that we have this information so we can prove these points. Without the data and all of the attack that's on DEI and research and removing the funding, this information is super important right now. We need to know the numbers and how we're voting. And we already know it, but we need the information so we can continue to prove it, so we can fight all of these things that they're doing in their different silos. They try to keep the information away from us so we don't have the information to fight. But it's very clear. The white people in Louisiana, Texas, Alabama, Oklahoma, we're great for fueling population growth, but they don't want us to have political power to be able to actually change things that benefit black people in a way that can elevate our communities.
I love this one here, Scott. Again, I appreciate Gary Chambers watching the show and sending me the documents. I love this here, Scott. It says, more broadly, the state's theory would impose a limitless obligation on Congress to continually refresh its legislative record for any statute enacted under the 14th or 15th Amendments, including laws like the Family and Medical Leave Act, Title II of the ADA, and the Fair Housing Act. The state identifies no limiting principle for this claim, and we see none. The Reconstruction Amendments do not demand that Congress re-justify its judgments on a rolling basis. Scott, at the end of the day, these white Republicans in Texas are like, do we have to give these Negroes something?
Hello, I'm Isaac Hayes III, founder and CEO of Fanbase. Listen to what I'm about to tell you. The window to invest in Fanbase is closing. We've raised over $10.6 million of our $17 million goal. That means there's room for less than 6,370 people to invest in Fanbase for the average amount. The minimum to invest in Fanbase right now is $399. That makes you an owner in Fanbase today. Go to startengine.com/fanbase to invest. Why? Because current social apps have taken advantage of users for far too long, with content suppression, shadow banning, harmful racist content, and no real tools for monetization and equity. Fanbase has over 1.4 million users and counting, allowing anyone to reach all their following and monetize their content from day one. Social media is the new TV, and whoever owns the apps that distribute that content have the opportunity to own potential billion-dollar companies. While big platforms with uncertain futures are failing to serve their users, Fanbase is stepping up to fill the gap. Don't wait until it's too late. Invest now, invest for yourself and your future. Go to startengine.com/fanbase and own the next generation of social media.